one for Mr. Trump and his cronies, and another for the rest of us. But that can only happen if you enable it. At your confirmation hearing, you were asked, do you believe a president could lawfully issue a pardon in exchange for the recipient's promise to not incriminate him? You said, no.
Not to what?
That would be a crime. You were asked, could a president issue a pardon in exchange for the recipient's promise to not incriminate him? And you responded, no, that would be a crime. Is that right?
Yes, I said that.
You said a crime. You didn't say it'd be wrong. You didn't say it'd be unlawful. You said it would be a crime. And when you said that a president swapping a pardon to silence a witness would be a crime, you were promising the American people that if you saw that, you would do something about it. Is that right?
That's right.
Now, Mr. Barr, are you investigating Donald Trump for commuting the prison sentence of his longtime friend and political advisor, Roger Stone?
No.
Why not?
Why should I?
Well, let's talk about that. Mr. Stone was convicted by a jury on 7 counts of lying in the Russia investigation. He bragged that he lied to save Trump's butt. But why would he lie? Your prosecutors, Mr. Barr, told a jury that Stone lied because the truth looked bad for Donald Trump. And what truth is that? Well, Donald Trump denied in written answers to the Russia investigators that he talked to Roger Stone during the time Roger Stone was in contact with agents of a Russian influence operation. There's evidence that Trump and Stone indeed did talk during that time. You would agree that it's a federal crime to lie under oath. Is that right?
Yes.
It's a crime for you, it's a crime for me, and it's certainly a crime for the President of the United States. Is that right?
Yes.
So if Donald Trump lied to the Mueller investigators, which you agree would be a crime, then Roger Stone was in a position to expose Donald Trump's lies. Are you familiar with the December 3rd, 2018 tweet where Donald Trump said Roger Stone had shown guts by not testifying against him? That it's a federal crime to lie under oath. Is that right? You don't read the president's tweets?
Yes.
It's a crime for you. There's a lot of evidence in the
me.
president's tweets, Mr. Attorney General. I think you should start reading them because he said Mr. Stone showed guts, but on July 10 of this year, Roger Stone declared to a reporter, Mueller investigators, I had 29 or 30 conversations with Trump during the campaign period. Trump knows I was under enormous pressure to turn on him. It would have eased my situation considerably, but I didn't. The prosecutors wanted me to play Judas. I refused. Are you familiar with that Stone statement?
Actually, I'm not.
So how can you sit here and tell us, why should I investigate the President of the United States if you're not even aware of the facts concerning the President using the pardon or commutation power to swap the silence of a witness?
Because we require a reliable predicate before we open a criminal investigation.
And I just gave to you, sir.
I don't consider it. I consider it a very Rube Goldberg theory that you have.
Well, it sounds like you're hearing this
and by the way, if I applied this standard, there'd be a lot more people under investigation.
Mr. Attorney General, the very same day that Roger Stone said that, Donald Trump,
that's one of the
no surprise,
the Trew.Tube standards of justice were really during the tail end of the Obama administration.
Mr. Attorney General, let's turn to the Michael Cohen case. Are you aware, sir, that Michael Cohen, after being released from prison, was asked to not engage with the media, including to write a book? Were you aware that that was going to be asked of him?
Was I aware?
Yes.
No.
Do you know if anyone else in your department was aware?
Maybe I should tell you what happened.
Why don't you tell us what happened?
Okay. He was furloughed from the Bureau of Prisons.
No. Why don't you tell us why he was asked?
I will tell you. Because something that people don't seem to understand is that his home confinement was not being supervised by the Bureau of Prisons. It was being supervised by the probation office, which is part of the U.S. court system. And it was the U.S. court system that had the requirements about not writing.
That U.S. court system called your actions retaliatory. Do you agree with that?
No. So all I know is what has been said in court before the judge and in the record, which is that the individual was then called by the U.S. court system saying that this guy, Cohen, is uncooperative, he's not agreeing to the conditions. And at that point, a Bureau of Prisons person made the decision that he was no longer eligible for home confinement.
Conditions that a federal judge said no other inmate had ever been asked of in his experience. Mr. Barr, you told ABC News that the president's tweets sometimes make your job impossible. But sir, your job is only impossible if you enable the president's corrupt schemes. And I yield back.
Thank you, Mr. Chairman. Mr. Attorney General, the Constitution says the President shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Do you note any other limitations in the Constitution on the President's power to pardon?
No.
Has the President exceeded that power?
No.
My colleague from Georgia, Mr. Johnson, implied that in challenging the sentencing recommendation of Roger Stone, you were doing the bidding of the President. He didn't want to hear your response. I would.
Well, no, I was, Roger Stone, I never discussed our sentencing recommendation with anyone outside the Department of Justice. It was a very condensed period of time. I first heard, I made the decision that we shouldn't take a position as to the precise sentence, but should leave it up to the judge. And we should not affirmatively advocate for 7 to 9 years, and I made that. And we should not affirmatively advocate for 7 to 9 years, and I made that. And we should not affirmatively advocate for 7 to 9 years, and I made that. And we should not affirmatively advocate for 7 to 9 years. So we did. As soon as I got in, we went forward with a plan to file. At that point, I learned about the president's tweet because I don't monitor the president's tweets. And I hesitated because I knew that I would be attacked for doing it, and people would argue that I did it because of the tweet. But I felt at the end of the day, I really had to go forward with our filing because it was the right thing to do, and I'm glad the judge agreed with it.
We're learning more and more about the targeting and prosecution and extortion of Michael Flynn by partisan officials at the FBI. No one has been held accountable for this grotesque abuse of power. Knowing that agents with a political agenda can take anything that someone says, edit it, misrepresent it, prosecute it, and then extort confessions by threatening family members, and to do so with impunity, why would anyone in his right mind ever want to talk to an FBI agent again?
Well, I don't, I haven't reached judgments, and I'm not suggesting that all those facts he set forth are true, and we have not at this point challenged the actions of I've defended the actions of the prosecutors in this case in court. The order of business right now is, knowing what we know now, we don't think any of the U.S. attorneys in the department would have prosecuted this case, partly because of the behavior of the FBI, but also because the evidence is not there to prove it beyond a reasonable doubt. And part of what I'm trying to establish is that we will use the same standards for everybody before we indict anybody, and this goes for both sides. We won't prosecute anybody unless there's proof beyond a reasonable doubt that they committed a crime, and not some kind of esoteric made-up crime, but a meat and potatoes crime.
For more than 3 years, the most powerful agencies in our government took information that was fabricated by agents of a political campaign that they knew was fraudulent, used it as justification to launch an investigation alleging treason against a presidential candidate, then leaked the existence of that investigation in a manner that was clearly calculated to affect the outcome of the election, and then failing that, used it in a largely successful attempt to obstruct the duly elected president. Are you going to be able to right this wrong before it becomes a precedent for future election interference by corrupt officials in our justice and intelligence agencies?
I really can't predict that. I think, as you know, John Durham is looking at all these matters. COVID did delay that action for a while, but he's working very diligently. And, justice is not something you order up on a schedule like you're ordering a pizza.
Well, there are many of us who are concerned that if you were succeeded by someone like Keith Ellison as Attorney General, that this will become an institutionalized practice and the investigation of Mr. Durham will simply go away.
I understand your concern.
One more thing, a term we keep hearing from the left is, these are mostly peaceful protests, mostly peaceful. It seems to me that you either are or you're not. Calling what's happening in our cities mostly peaceful protests is a lot like calling Scott Peterson a mostly faithful husband or Al Capone a mostly law-abiding businessman. There is a constitutional right to peaceably assemble. Where does that right stop?
When it becomes violence, criminal activity. And that's the challenge here. I mean, you have a lot of people who are out protesting and demonstrating, and that's important First Amendment activity that we believe strongly in and try to protect. The particular violent opportunists that are involved here get into those crowds and then start engaging in very violent activity and hijack it. And a lot of protesters have been telling law enforcement and providing information to us about these people who are not with them, they're not demonstrators, but they're coming in. And a lot of the demonstrators leave when that happens because they see what's happening themselves.
Would you call that violence a myth?
Gentleman's time?
No.
The gentleman's time has expired. Mr. Liu.
Thank you, Mr. Chair. Thank you, Mr. Barr, for being here today. I'd like to ask you some questions about the legal standard for seizing and arresting protesters. Under the Fourth Amendment, it requires probable cause before you can seize and arrest a protester, correct?
Yes. Yes.
Okay, and the probable cause has to be particularized to a particular person. So if a protester was merely standing around in a crowd in the vicinity of someone else suspected of criminal activity, you cannot arrest that peaceful protester. In other words, there's no such thing as probable cause by mere association, correct?
Well, not strictly, but I'll say that, you do need particularized probable cause.
Okay, and if there's no probable cause,
If someone jumps into a getaway car
correct?
and there are 3 or 4 people in there, that might be enough to give you probable cause, just those circumstances. You don't need it on each individual.
Reclaiming my time, Mr. Attorney General. If there's no probable cause, you can't arrest a protester, correct?
I said at the beginning, arrest has to be predicated on probable cause.
All right. Now, an arrest can also occur whether or not the federal official says it's an arrest. So, for example, if a federal officer takes a protester into custody, transport that protester, let's say, to a federal building, detains a person for questioning, that will constitute an arrest whether or not the federal official says the person is under arrest, correct?
Well, that would require a very intensive review of all the specifics involved.
Actually, it wouldn't. In the case of Dunaway versus New York, which is black letter law for over 40 years, the question was whether the police violated the 4th and 15th Amendments when, without probable cause to arrest, they took petitioners into custody, transported him to a police station, and detained him for questioning. So the answer is yes, that would constitute an arrest.
No, the answer is that, Fourth Amendment is ultimately governed by reasonableness, and there can be circumstances. The question sometimes is, when does something actually become custody?
Reclaiming my time, this is not a trick question, Mr. Barr. I'm just citing you what the Supreme Court said. So here's a problem. Under this standard black letter law, which has been in effect for over 40 years, what the federal forces in Portland did was unconstitutional. Federal forces in full combat gear, in the dark of night, grabbed a protester who was peacefully standing there, forced him into an unmarked van, drove him to a separate location, searched him, detained him, and questioned him. That is what police states do. That's what authoritarian regimes do.
But I don't think those were the facts.
I haven't asked you a question yet, Mr. Barr.
Okay.
What the federal officials did was illegal because they didn't have probable cause. And how do we know that? Because Deputy Director of the Federal Protective Service, Chris Klein, admitted it on national TV. Deputy Director Klein said that the individual that they were questioning was in a crowd and in an area where another individual was aiming a laser at the eyes of officers. That's guilt by association. That's what the Fourth Amendment prohibits. Deputy Director Klein further stated that the protester was released after federal officials concluded, quote, they did not have what they needed, unquote, which again shows there's no probable cause. And it appears that federal Deputy Director Klein appears to understand that there was no probable cause because he essentially justifies that action as saying it wasn't an arrest. He calls it, quote, a simple engagement, unquote. I'm a former prosecutor. I've never heard that term, a simple engagement, because it's a made-up excuse. What these federal officials did was an arrest. They grabbed a peaceful protester, they forced him into a van, drove him to another location, questioned him. That is exactly what the Supreme Court prohibited over 40 years ago.
So
And
I
that's not an
obviously,
isolated incident.
I obviously don't know
In a
that.
Washington Post, I haven't asked you a question yet. In a Washington Post article on July 24th entitled Operation Diligent Valor, federal agents told reporters that there's no basis for these arrests. They said, quote, at times they have grabbed an individual and taken them inside the courthouse for questioning before determining that they had no probable cause to charge him with any crime, unquote. Deputy Director Klein said that they coordinate with the U.S. Attorney's Office on all of these arrests. I urge you to instruct your federal officials to comply with the Constitution, and I ask you to investigate these arrests because many of them are in violation of the Fourth Amendment. We do not live in a police state. We're better than that. I yield back.
Gentleman yields back. Ms. Lesko?
Thank you, Mr. Chair. Since Representative Liu didn't allow you any time to answer his allegations, would you care to answer any of his allegations?
Yes, I mean, obviously, I don't know all the particulars of any individual case out there, but based on my general understanding, what had happened was that when they tried to effectuate arrests of the ringleaders or the people who were engaged in violence or that they saw with lasers and so forth, and they went out, they were immediately swarmed by people in black, and there was a lot of violence, so they couldn't effectuate the arrest. So the modus operandi was changed, and based on specific information as to individuals who were seen doing things and identified, they later tried to pick them up when there was less of a risk of this kind of mob response. The fact that if you have information that someone has a laser and is using it and later pick him up and he doesn't have it, it doesn't mean that there wasn't probable cause. It means he doesn't have the laser. The question is, was it reasonable for you to rely on the information that you had and the identification of that individual? In some cases, it could be a misidentification. In other cases, it could be the person, ditched the laser. So there is a distinction between whether the person ultimately can be shown to have violated the law and whether there was probable cause for the police to make the inquiry and take them and interrogate them or ask them questions at least.
Thank you, Mr. Attorney General. I think I have to tell you, you probably know this, my constituents are scared. Americans are scared. I mean, they watch the TV, they see all this rioting, looting going on, statues being torn down. In Arizona, where I'm from, more guns are being sold than ever. I think there's more new gun owners than ever. And this has to stop. And I think that it's really important, as the saying goes, that in order to solve a problem, the first step is to realize there's a problem. And so I find it very disturbing, should I say, that Chairman Nadler denies that Antifa even exists. He said it to a reporter. He said on the floor of the United States House of Representatives that it was a fantasy, a made-up fantasy. And then in this very room, just recently, Congresswoman Jayapal, who represents the Seattle area, said, when I was talking about the autonomous zone and the takeover, she said, the area is just a few miles from where I sit right now, and there is no takeover. There is no takeover. She also said, lies are being spread by my colleagues in this committee. This area is perfectly peaceful. She also said, my Republican colleagues keep saying the Seattle Police Precinct was taken over by protesters. This is incorrect. Incorrect. No one has taken over that building. Mr. Attorney General, is that your understanding of what happened there? Do you agree with Ms. Jayapal that there was no takeover? It was just
Jayapal.
peaceful?
If you're going to say my name, please
Jayapal?
say it right. It's Jayapal.
Jayapal, would you agree with that? And also, in answer, why do you think these autonomous zones in Democrat-led cities are dangerous to America?
Well, starting with they're dangerous because they are purporting to keep on the outside duly constituted authority of the government. they're also, to me, outrageous because the people who are living now under this autonomous zone haven't selected the government. They've selected the duly authorized government of the city and the state. So it's quite an outrage that people would use force to take over an area. What makes me concerned for the country is this is the first time in my memory that the leaders of one of our great two political parties, the Democratic Party, are not coming out and condemning mob violence and the attack on federal courts. Why can't we just say, the violence against federal courts has to stop? Could we hear something like that?
Mr. Attorney General, I totally agree. I support what you're doing, and I support what President Trump is doing for law and order in our country, and I yield back.
Gentlelady yields back. The committee will stand in recess for 5 minutes.